दोस्तों, मैं रोहित कुमार एवनीशो की ओर से आपका स्वागत करता हूं।
In the second lecture of the series, I'll be discussing with you a school of analytical positivism. And today, I'll discuss with you Bentham's concept of law and the introduction of John Austin's theory of law. So, starting with Sir Jeremy Bentham, G-E-R-E-M-Y, Jeremy Bentham, B-E-N-T-H-A-M. His time period was 1748 to 1832. Truly, Jeremy Bentham was the founder of the school of analytical positivism. People consider John Austin as a father of analytical positivism, but this is not true. Actually, John Austin's writings came to light very lately. In fact, after the Second World War, his writing came to light. Actually, John Austin owes very much to Jeremy Bentham, and some of the works of John Austin is no more than a paraphrasing of Jeremy Bentham's view. So Jeremy Bentham was a champion of codified law, that is legislation. So he wanted all the laws should be codified. Bentham's work was intended to provide the indispensable introduction of a civil code, that is pattern. So he used to explain a lot about civil code. Bentham distinguished expositorial jurisprudence, that means what the law is. That means the existing laws, the actual laws, or in other words, actually existing laws, from sensorial jurisprudence. He distinguished expositorial jurisprudence with sensorial jurisprudence. And sensorial jurisprudence means what the law ought to be. That means ideal laws, moral laws. So Jeremy Bentham perhaps was the first one who distinguished positive law with the natural law. That means he distinguished expositorial jurisprudence with sensorial jurisprudence. His concept of law is an imperative one. That means he says that people or society is duty bound to follow the law. His concept of law is imperative one. And his definition of law is, please note down his definition of law. Law is assemblage of science, declaration of volition conceived or adopted by a sovereign in a state. I'll explain this definition. Law is assemblage of science. That means law is a collection of those signs or those indications. In other words, it is declaration of volition, declaration of will, which is conceived or adopted by a sovereign. Who is a sovereign? A political superior. It is a declaration of volition conceived or adopted by a sovereign in a state. So I'm repeating it again. Law is assemblage of signs. That means law is collection of those indications or those signs, or in other words, it is declaration of will, which is conceived or adopted by a political superior known as a sovereign in a particular state. That is his definition of law. So he was the first one who distinguished positive law from natural law. He supported the principle of the laissez-faire, economic principle of laissez-faire. That means minimum interference of the state in the economic activities of the individuals. He propounded the principle of utilitarianism also. What is that? Utilitarianism means the proper end of every law is the promotion of the greatest happiness of the greatest number of the people. And what is utility for him? Then utility means property or tendency of a thing to prevent some evil, that is pain, or to procure some good or pleasure. So he says that man lives in an empire of pleasure and pain. He tries to avoid pain and tries to secure pleasure for himself. According to him, function of every law must be to meet these ends. That means to promote greatest happiness of the greatest number of the people, or to produce abundance in a society. End of law is to provide subsistence, to produce abundance in a society, and to favor equality, and also to maintain security. So his theory was just in the favor of promoting security, promoting equality, provide subsistence to the people, and to produce abundance in a society. So his theory was favoring those communities which was involved in trade and commerce, which was involved in industrialization. So this was a time when capitalism was taking its stronghold in the society. Feudal society was making its way to the capitalism. So this was the first theory of its kind, although Bentham's doctrine of hedonism, that is pleasure and pain, was bitterly criticized on the ground that pleasure and pain is not only final test of the adequacy of law. There are other things also. So that is Jeremy Bentham. When you will write your answer on John Austin, you have to mention at least his definition of law, which I have already discussed. We will now discuss John Austin, who is a disciple of Jeremy Bentham. His period is 1790 to 1859. He is considered to be the founder of the school of analytical positivism. Although I have told you that this is not correct. Actual founder of the school of analytical positivism was Jeremy Bentham. So John Austin is considered as the father of English jurisprudence. John Austin was elected to the chair of jurisprudence in the University of London in 1826. After that, he proceeded to Germany. He went to Germany after that, and he devoted some time to the study of Roman law there, because Roman law was being accepted in various parts of Germany as a part of Germany. So John Austin had an opportunity to study Roman law there. The scientific arrangement of Roman law, or the scientific treatment of Roman law in Germany, made him aware of the chaotic legal exposition of law in his own country, that is England. So when he started the study of Roman law, he found that the treatment of law is a very chaotic one in England. So he took some inspiration from the treatment of Roman law in Germany, and he proceeded to make a scientific arrangement of English law. It was John Austin who tried to make a scientific arrangement of the English law. The method that he applied was essentially of English origin. तो उसने जो method apply किया, उन्होंने जो method apply किया John Austin ने, that was not a German method or a Roman method. He applied the method of the English origin to arrange English law scientifically. John Austin avoided metaphysical method, which is of a German origin. Now I'll discuss in short the work of John Austin. As I told you that John Austin was elected as a chair of jurisprudence in the London University. His lectures, which he delivered in the London University, were published under the title The Province of Jurisprudence Determined. And this is the title of his book. And till today, this book remains to be the very famous book of John Austin. In his lectures that is published under the title Province of Jurisprudence Determined, he dealt with the nature of law and its proper bounds. That means what is a nature of law and what are the proper boundaries of law. What should we study under the subject jurisprudence? And that is why the name of the book that he wrote, not the one which he wrote, in fact, collection of his lectures. The name of that book is a Province of Jurisprudence Determined. He is trying to determine those provinces, those areas which can be studied under jurisprudence. In that book, he also discussed the sources of law, and then he presented an analysis of English legal system to explain the nature and sources of law. Later on, he wrote another book, and the name of that book is a plea for the Constitution. The answer to the criticism by Gray, and the name of that book written by John Austin was Parliamentary Government. But main contribution to the jurisprudence made by John Austin is his first book, that is The Province of Jurisprudence Determined. And on that book rests the popularity of John Austin. Now let us discuss his methods. The method which John Austin applied is called analytical method, and he confined his field of study only to the positive law. So positive law क्या है वो हम डिस्कस करेंगे थोड़ी देर बाद, अगले लेक्चर में इनफैक्ट डिस्कस करेंगे. So he confined his study only to the positive law. That means law strictly and simply so called. And therefore the school which John Austin founded is known by different names. Some people call it analytical school, some people call it the school of positivism, some people call it a school of analytical positivism, and some thinkers have objected to all these three terms, analytical, positivism, and then analytical positivism. They have objected to all three names. They say that the word positivism was started by Auguste Comte, and he had started this word positivism to indicate a particular method of study, although this positivism later on prepared the way for the 19th century legal thought, but it does not convey exactly the same sense at all the places, both the places. And therefore, the word positivism will not give a complete idea of the school which is founded by John Austin. Similarly, analysis also did not remain confined only to the school founded by John Austin. Analysis तो कोई भी कर सकता है. So it did not remain confined to the school which is founded by John Austin. And therefore, this also cannot give a separate identity to the school. Analytical positivism also may create confusion because the Vienna school that is founded by Hans Kelsen in his Pure Theory of Law also applies analytical positivism to its school. Although in many respects, school founded by Hans Kelsen is very different from Austin school, but it applied the same method, and therefore you cannot say that the school founded by John Austin is an analytical school. And to avoid this confusion and give clarity, which is the aim of classification, Professor Allen, A-L-L-E-N, thinks this school founded by John Austin should be called the imperative school. And he says that this name is a proper name to the school founded by John Austin. And this name Professor Allen has given on the basis of Austin conception of law, that law is command. So in the next lecture, we will discuss the theory of John Austin, and we will discuss it into two parts. First, Austin conception of law, and second, the method of law which John Austin has used for his study. I will start here a little bit with the concept of law. I will end it in another 2 minutes. John Austin says that law in the common use means, and it also includes those things which cannot be properly called law. Now, question is, which are those things which cannot be called law properly? They may be law of positive morality, law set by opinions or sentiments, laws metaphorical or laws figurative, or even law of God. So what should be studied under jurisprudence? Only and only the positive law. In order to understand that, let us see the definition of law given by John Austin. John Austin defined law as a rule laid down for the guidance of an intelligent being. Law is a rule laid down for the guidance of whom? Of an intelligent being. By whom? By an intelligent being, but having power over him. So law is nothing but it is a rule laid down. Why it is laid down? It is laid down for the guidance of whom? Of an intelligent being. Who laid down this rule? Rule is laid down by an intelligent being, but the main essence of it is the power over other intelligent beings. So intelligent beings who are laying down the rules for the intelligent beings should have a power to lay down those rules, because the enforceability of law is possible only if the rule maker has a power. We will discuss that in the next lecture.
दोस्तों, इस तरह के वीडियो को बनाने में काफी समय, मेहनत और रिसोर्सेस लगता है। आप अपना वैल्यूएबल फीडबैक जरूर शेयर करें ताकि एबनिशियो टीम को प्रोत्साहन मिले तथा आपके द्वारा दिए गए फीडबैक पर काम करके और इन्फॉर्मेटिव वीडियोस आप तक लाया जा सके। यदि आपको यह वीडियो पसंद आया हो तो प्लीज लाइक द वीडियो, subscribe the channel and share the video with needy one. Thank you for watching videos. Thanks a lot.